there is evidence that suggests that the word arose during the Roman period of Justinian, which meant corpus. Corpus means a body of people. And there's evidence that suggests that ancient corporations existed as a body of people. In the medieval times, the corpus or the body of people organized themselves, for example, like the City of London Corporation, and the Pope also had a corporation, and allegedly the oldest commercial enterprise was granted by a charter that was extended by King Magnus Eriksson of Sweden to a company known as Stora Kopparberg, and that was in 1347. During the later periods, the royal decrees extended corporations or royal decrees to various entities, one of them known as the Dutch East India Company. And perhaps the most well-known company was the British East India Company, later on the East India Company Limited. As we know, this company stayed a long time in India and ruled the Cape of Good Hope as it was then known. As company law progressed through the ages, the distinct difference between a company and its shareholders was pronounced in the matter of Salmon versus A. Salmon on the 16th of November 1896 in London. Now that's the starting point of our discussion and helping us to understand what a company is, what their shareholders are, who their shareholders can be, what a director of the company is, what the director's responsibilities are, is my very special guest, Advocate Mohammed Desai. Mohammed, assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam.
And welcome tonight to Legalese.
Desai.
And thank you for trying to make us understand what this whole topic will be about. Now, Mohammed, what is the starting point? Really, in terms of South African law, what are we to understand by a company?
Well, Ashraf, a company is in itself a legal personality, an independent legal entity. It's constituted by the Companies Act itself, and that's the statute and where it derives all powers from.
Right.
Now, yes, coupled with that is, of course, the individual structures in the company itself. So you've got the body, the corpus, as you might have dealt with it earlier, which is the shareholders. And then you've got, of course, the directors and several other office bearers.
Right. Now, obviously, a shareholder may also be a director. Now, there is a distinct difference between the offices of the shareholder and the offices of the director. In other words, the shareholders may hold the shares in the company, but they don't necessarily own the company. Is that correct?
Well, a share in itself is a form of movable property. So you own an item,
right,
an item that entitles you to certain rights. Now, the control of the company,
yes,
is a distinct and separate classification altogether, because the control falls within the prerogative of the directors. So more often than not, especially with larger entities and the like, a shareholder is someone who would put in money and buy a share. And by that he has certain legal rights, like I said. We'll deal with that perhaps in more detail later. And he abdicates his responsibilities, his management control and day-to-day running of the business to the directors themselves. Now, we'll also, I'm sure, get to the massive burden, the yoke placed on the directors.
Right. So, in the company itself, what is the first essential step? Is registration the first essential step? And what do you need to do in order to register a company? More especially now that close corporations have been phased out as legal entities in this country. So you can no longer register a close corporation,
As such.
but You can continue with the closed corporation that you had, but you cannot register a new closed corporation. Of course, there are other legal entities in which you can conduct business, for example, through a trust, a sole proprietorship, or a partnership.
Sure.
But by far, the most popular way of operating a business is via the means of a limited liability company, correct?
Yes. Well, let's start with, of course, you said these steps. Now, first and foremost, the Companies Act, and I believe, if I remember correctly, from Section 13, affords a right to any person to register an entity, a separate legal entity, a company. How that is done is by the shareholders or parties signing a memorandum of incorporation and registering it with the relevant body, which is the Companies and Intellectual Properties Commission, or CIPC. From there, there's an issue of a certificate of incorporation. Now, this entity exists as an independent entity from date of the certificate of incorporation being provided. As you've indicated, there are numerous entities or vehicles for conducting business in South Africa. Most importantly, though, the company. And companies, they dominate the landscape of business in our country, without a doubt.
Now, you have companies that are limited liability companies, and then they designated by the words Pty Limited at the end of their name, and you have companies that are limited. Is there a difference between the two?
Well, let's start perhaps with the biggest division in the Companies Act.
Yes.
You get the profit companies and the non-profit companies.
Okay.
Now, your non-profit ones are registered for some egalitarian purpose or the other, or the, you know?
Like a charitable purpose,
charitable,
or
yeah.
some other purpose.
Yeah, some
right.
benevolent purpose,
Right.
of course. On the other hand, you have your profit companies. Now, you have your limited companies, which are your public companies, which afford shares to the public at large. And then you have your private companies. Now, your private company is typically what a small to medium enterprise would comprise of. The requirements in respect of governance of each is vast.
Right.
More liability and more is required of a limited company which offers its shares to the public.
Right, like a big listed company.
Yeah.
Okay. And look, tonight's topic is corporate governance, which we will unpack shortly, but just by way of background. So how many shareholders can a, let's say, Pty Limited have? Is it a specific number or unlimited?
If I remember correctly, I think it's limited to a Pty Limited, for that matter. Limited is unlimited.
Okay.
But a Pty Limited, if I remember correctly, and I stand to be corrected here, should be up to 20 or 50. I can't remember offhand though.
Okay. So basically, if a group of people, I mean, one person can form a company, correct?
Yes, of
A
course.
single shareholder.
Of course.
He owns 100% of the shares, and you're saying there's a regulatory framework. He goes to SIPS in Pretoria, and he registers this company, and he gets a memorandum. Well, he registered the memorandum of incorporation. Now, recently there was a change in the law. There were companies, old companies, and that had a memorandum of incorporation.
Sure.
And there was a cutoff date, and then either you had to tailor your memorandum of incorporation in terms of the New Companies Act, or you would have to form a new MOI, right?
Sure.
So can you just tell us about that a bit?
Well, we must remember that our old Companies Act, 1973 was the year in which it came into play.
Right.
And our newer Companies Act, our New Companies Act, is 2008.
Right.
So there was a 30-year lull in company laws, so to speak. Of course, there were amendments and the like across the board, but there were obvious reforms in the New Companies Act.
Right.
Now, of course, you did not put an end to entities in their entirety, but there were several changes in the Memorandum of Incorporation. It's more of a conversion than a tailoring as such. So
right.
You would convert. Of course, if you didn't, you stuck with certain other implications.
Right. Now, What advice would you give to shareholders when they're forming a company in respect of shares? How are shares to be structured? In this regard, I'm really pointing out to the old preferential shares that was there,
Sure.
and ordinary shares. Now, in a simple way, what kind of shares could one register in a company?
Well, like you said, of course, you've got your preferential and all the other shares that come with it. You've also got your shares. Well, you see, fundamentally, you've got your par value shares and the like.
Okay.
So you have to consider what type of an investment you're bringing in, what would be the value of the shares and the like.
Right.
So it's a very complicated question depending on the circumstances of your particular entity.
Yeah.
And of course, the business purpose and objective.
Does the shareholding itself dictate the kind of board that you would be running? In other words, can a particular shareholder dictate to the board of directors what he or she would like to see?
Well, how they dictate, they could dictate.
Yes.
And there's two particular ways in which you can. The first is your memorandum of incorporation itself. Because by virtue of the memorandum of incorporation, you can place restrictions and limitations on the powers of directors. So you do have the right there to suggest how things should be done. You also have certain other available powers in terms of your memorandum of incorporation. The second way to dictate is to appoint directors. Now, that might sound counterintuitive to an extent, but once you've appointed a director and you've formed a board, that board and those directors have the control over that entity. So they are in charge of that entity, and they have to ensure that that entity is correctly run. At that point, a shareholder cannot usurp the function of that board. You do have recourse, perhaps, if you are displeased with the performance of the shareholders, you could have them removed. But you can't dictate, you can't tell them, I own 60 shares, so because I own 60 shares, they must do A, B, C, D. In fact, they will tell you what they're going to do and report back to you once they've done what they have to do.
So they're the real servants of the company. And being servants of the company, there's certain, let's say, responsibilities that they have to comply with. For example, the fiduciary duty.
Sure.
Now, let's talk a little bit about what are the roles and responsibilities of a director as prescribed in the Companies Act?
Well, to start there, you have two roles. And well, you need to understand a company acts, of course, internally. You have your internal structures and obligations that the directors owe internally. And also there's a third party type of an obligation, so to the world. What is owed by the company and the directors to the world. In terms of what is owed to the company and the shareholders and the shares and stakeholders, as it would be, one has to begin with the basic duty and obligations of the directors. And that's, of course, to perform the tasks and control and manage the company. Now, stemming from that is the requirement which stems of all professionals and all persons in some capacity or the other, which is to carry out those tasks as a reasonable person would.
Right.
Or rather, in this case, a reasonable director would.
Right.
Yeah. Coupled with that, one has to recognize that the shareholders are placed in a position of trust. Now, what this trust dictates is that each shareholder, or director, I apologize, each director must ensure that they act in the best interests of the company. They must act in the, make sure that they do not compete with the company. They must not make secret profits of the company.
Right.
So there's numerous of them in Section 77 of the Companies Act.
Right. Now, an example of fiduciary duty, I suppose, would be if the company has identified a property and it's willing to pay a premium for it. I mean, the director can't go secretly and bid for the property, become owner of the property, and then sell it to the company at a excessive profit, that would obviously be in breach of his fiduciary duty.
Undoubtedly. Of course, the obligations, as I've pointed out, you can't compete and make secret profits. Of course, you must act in the company's best interest, and you must act with utmost good faith. So that requires of you to ensure that you don't breach those duties. You can't steal an opportunity in the simplest form, in the simplest terms. That would be stealing an opportunity from the company.
Okay, that appears to be a convenient place to pause. We're going for a short ad break. Please stay tuned and join us after this break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Now tonight I'm joined by Advocate Mohammed Desai, and we are speaking about a topic that's very important to business people, which is that of corporate governance. Not just to business people, even entities that run what used to be known as Section 21 companies, because the company laws apply to all of these entities. We paused at the point where we were speaking about the director's responsibility regarding the company and not to compete with the company itself. But that was the internal responsibilities. Mohammed, is there an external responsibility directors have?
Sure. One must remember that the directors effectively exercise the powers of the company.
Right.
Now, like any other ordinary human being, you of course can't perpetrate frauds or act in reckless and negligent manners in respect of other persons. Now, the Companies Act includes specific provisions in respect of the directors and their outward manifestation of their obligations. In respect of third parties, you must ensure that the entity is not run in a reckless, negligent manner, or there's a unconscionable abuse of the separate legal personality of the entity. That sounds very tricky, unconscionable abuse. But a prime example, and I see this more often than not in my practice, is persons not respecting the entity's separate legal personality. A prime example, as said, is perhaps the Ibrahim and cold storage decision. It's somewhat the locus classicus on the point of abuse of a separate legal personality. It's decided under the old Companies Act, but equally pertinent to the current Act, from what I can recall is Section 20 sub 9 of the Act itself. In that matter, there was a father and son running a particular company. There are two companies. One was VAT registered and the other wasn't. So to conduct their business, they required VAT registration, and they decided, well, the company that was not VAT registered should transfer all assets to the company that was VAT registered. What they then did was continue to trade, but they left liabilities with a company that did not have the VAT registration.
And didn't have any assets.
And no assets.
Right.
And at some point, the creditors of the company themselves came after the company that was not VAT registered, and they found nothing in the coffers to satisfy their claims. Of course, then, in terms of the company's law, they were entitled to look behind the veil, the corporate veil, to consider whether the directors had abused the separate legal personality. And in this case, because there was no transfer for the assets, there was no quid pro quo from the VAT registered company for the assets itself, the courts found that there was an abuse. So the entity, the non-VAT reg entity, and the VAT reg entity for that matter, were both utilized as the alter ego of the directors there.
Right.
And it's far too often that we see this, that people register entities and they don't respect. The primary purpose of the Companies Act is to establish an entity. And I try to explain this daily in my practice, that it's separate. It's as though there's two of us. Ashraf, you are your own person and I'm my own person.
Yeah.
I can't conduct your activities and I can't, usurp any of your powers.
Yes.
I must look after your interests if I'm in charge of your interests. but I
Right.
can't conduct you as me.
Yes.
People just that seems to escape a lot of people, and it causes great difficulty. People just don't respect it. Those are two of the obligations, but of course, in terms of Section 218 of the New Companies Act, there's a very broad provision there which says that any breach of the Companies Act itself may visit any person with liability. Now, any person could be directors, shareholders, or whomever, and any breach could be anything other than just, for that matter, reckless trading, fraudulent trading, or, of course, an abuse of the separate legal personality.
Right.
Another interesting provision is Section 214 of the Companies Act, because their false statements could equally visit a liability, personal liability on any person making that statement. So those sections effectively rob that person of the vestige and the aegis of the company itself. So they remove that shield.
So basically, the theory that a company has a separate legal personality is not an absolute given. What you're saying is, in certain circumstances, the Act provides that the courts or the creditors can go beyond the veil that separates the shareholder and the company or the directors. And what you're saying is any person may be held liable, which is quite startling and broad.
Well, your first question when you asked me this question was the theory. In truth, the entity is separate. That's where the matter ends.
Right.
People, however, abuse that entity.
Right.
And with that comes the implication of the removal of the veil itself. Now, coupled with that is that any person,
Yes.
and that's the person who's acting in concert, the person who's obviously aiding the unlawful acts, or the acts that counter the specific provisions and purpose of the company itself. And that person as well may be found liable. So even if you're a manager or an employee, lower level employee who's just going along, sometimes it could be by omission, closing your eyes. You know something's happening, you know you should deal with it, but you let it run.
I suppose a glaring example would be environmental damage. You know, often we have a situation where companies would weigh into a particular venture and take shortcuts. Now, what you're suggesting that even ordinary employees that may know about this and decide to close their eyes to it could be found liable.
Well, of course, it must be in the appropriate circumstances.
Yes.
But you must remember, every person has a moral and legal obligation to report any wrongdoing. And we have numerous acts for those purposes. The Protected Disclosures Act. The company themselves are required to establish a line for reporting of irregularities. The board itself must establish such lines and must ensure that these lines are well looked after. You've touched on something very interesting, because you've dealt with environmental damage, just by way of example. But with the public listed companies,
Yes.
they are obliged to comply with the King's report, the King 3 report,
3, yes.
as it's called. Now, King 3 requires you to consider all risk, and it says and it suggests and it requires that each director and board of directors takes a risk-based approach. So included in that, and when we say risk, because what companies and directors don't realize more often than not, is that they do not operate in a vacuum.
Right.
They are a microcosm in the bigger macrocosm.
Yes.
So they obviously have and leave a footprint on the rest of the environment and everything around them. King 3 requires part of your risk to consider the environmental impact, societal impact, and also consider aspects like employees. Those are part of your risks and your risk-based analysis. So you could be held liable, and of course, you must have some active role. But I could claim against you.
Right.
I could claim against you in the appropriate circumstances. You shut your eyes. You shut your mouth. You had a duty to speak.
Right. So it's not all, let's say, comfortable for you simply to say the board of directors was in charge and they're responsible. I think what we're saying now is the duty and responsibility visits each and every person involved in the organization with knowledge of the wrongdoing.
Sure. You see, of course, we answering a very broad question there, and there's a multitude of possible answers because there's too many what-ifs. But if you have a duty to speak, for instance, I'm an employee, I'm employed on a particular aspect or particular portion of the works. Or just say we've contracted with a party to do A or B or C or whatever the case might be. And I know of some impropriety in the acts of the company.
Yes.
I may well, in those circumstances, have a duty to speak. And if I fail to speak, I may well find myself liable for those debts. It's very rare, though, to find an employee, unless he himself has committed some part of a fraud, actively involved in some case in which he has to compensate some other party. More often than not, and as is the norm and what is required, is that the directors themselves are personally liable for the breach of any obligation to a third party or otherwise, where it's reckless, negligent, or an unconscionable abuse for that matter.
Okay, and that appears to be a convenient place to pause. We're going for a short ad break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. And thank you for joining us once again on Legal Ease, the show that converts legal jargon into legal ease. Here's a reminder that the lines are open and you're entitled to call on 011 086 7700 1, 2 or 3, and the number appears on the screen. Just a reminder that we're talking about company law and specifically corporate governance, and I'm joined by Advocate Mohammed Desai from the Johannesburg Bar to help us better understand this topic. Mohammed, what about the financial side or the audits or the auditing of a company? And that's very, very important.
Sure. Ashraf, to answer that, we must also consider that every company, every director or board of directors and company itself is obliged to prepare certain reports. Now, the reports are intended to be also multi-directional. In the one instance, they provide invaluable knowledge to shareholders, because it's recalled that it's the directors who look after the interests of the shareholders. And in the other direction, it also ensures that there's compliance with the Companies Act and financials are filed when they need to be filed. Now, the Companies Act, apart from the directors and shareholders, specifies certain other office bearers. These are not required for your small, medium enterprises. I'm going to refer to them as that, but more your private companies.
Right.
For your listed companies, however, and your public companies, you have to have certain other office bearers, which are your audit committee, your auditor, and a company secretary. Now, as the names would suggest, your auditor must ensure proper financial compliance and ensure that there's no improprieties. It's just a very overarching position that they have. It's not a complete and comprehensive, detailed analysis of their obligations. It's quite a lot for an internal auditor. Your audit committee as well must ensure that the company is well run, there's integrity in the financial reporting. They must also link between the two different, the internal audit and the external audit. They must ensure that there's a bridge between the two. In terms of King 3, now, when I refer to King 3, it's not intended for King 3 to apply to small to medium enterprises and the like, unless they specifically say that it should apply.
Right.
Now the shareholders could do that via their memorandum of incorporation, or the directors could do that through the company rules. But of course they would have to be more specific about the manner. They can't just say King 3 applies.
Right.
You have to find the specific provisions that you want to deal with and include those in there. The Companies Act in their schedules also incorporates to a large extent what was King 2 at that point. King 3, from what I can recall, was the third iteration which came out after the Companies Act itself, the new Companies Act, but it broadens on King 2 and deals with IT risks and the like. But going back to the external auditors and the audit committee, in terms of King 3 though, the audit committee is also obliged to ensure an overlooked
Can I ask you
risk.
to just please pause there? We have a caller on the line. Caller, please go ahead. Hello?
Hello, Mohammed, how are you?
Fine, and yourself?
Yeah, good, thank you. Mohammed, my name's Dean. I'm just wondering if there's any way, in terms of our law at the moment, which you can go after a member of a CC. I'll put down my phone and here on TV.
Before you go, Dean, let's just understand your question. What do you mean? Are you a co-member in the CC, or are you not a member in the CC? Are you aggrieved by something the CC has done? What is your question exactly?
If a CC is liable for a debt, could you go after a member of a CC at present?
Well,
in his personal capacity?
That's correct.
Okay, Mohammed?
Well, Dean, the primary difference between a CC and a company, let's begin there, is that the CC itself is constituted by its members. The members would effectively act as both shareholders and directors of the company. So they have the decision-making powers of the closed corporation itself as opposed to a company. I apologize. Of course you can. It's wholly dependent on the facts. And the Closed Corporation Act incorporates the Companies Act in those respects and says if they have operated recklessly, fraudulently, or they've carried on the business for a fraudulent purpose, abused the separate personality of the business, then yes, you can. However, one must recall that the entire basis of the entities and their structures is to ensure that there's some immunity afforded to both either the members, as you've requested, or the directors. So you will have to overcome that immunity, and you'll have to show some type of reckless, fraudulent, or grossly negligent trading, or for that matter, again, unconscionable abuse of the separate legal personality. It's no easy task to do that as well. And look, there's no requirement for the reckless trading to have caused your loss as such. There's no causation requirement. But it's a rather cumbersome and difficult task to prove. By way of evidence, it's hard to prove.
But Mohammed, isn't it also true that the correct time in which to go, in the caller's own words, to go after a member would be after the dissolution of that entity?
Well,
probably in an insolvency inquiry,
sure,
where you can call for documents and books.
Well, Ashraf, you can go after the company, and we use those words, go after, which sound rather harsh, or the members themselves, go after the members. You can go after them while the company is alive.
Right.
But what Ashraf is saying, and it's quite important to understand, that once an entity has been or placed into liquidation, its books of account and the like are opened up. And from there, you can create a bird's eye view of the conduct of the company and the manner in which the company was conducted. For instance, is there a misappropriation of funds?
Yeah.
Is there by misappropriation of assets? How the company's books were run becomes very important. And you still have the provisions of the insolvency inquiries, where you can still go ahead and inquire into the conduct of the company and subpoena people to the magistrate's court and the like to ensure that question them on the manner in which they've run the company itself, or in your case, the closed corporation.
I think the earlier example you gave was quite important, that of the Ibrahim and cold storage matter. I mean, there was a clear intention to circumvent the events that led to the creditors coming after them,
Sure.
Which was is to operate a shell company with no assets and then not really transfer the assets into the other company, but not for good, let's say, good cause, or for true value. Yeah.
Value.
Yes. Okay. I hope that answers your question. Mohammed, we were talking about the audit committee and responsibilities and the
Sure.
King 3 reports. Just for the sake of the viewers, just unpack what is King 3 and why is it important?
Well, the King 3 report, as it's been named, like I said, it's the third iteration, so the number 3 refers to the iteration of the report itself. King
But it doesn't refer to a king. There was a judge.
The Supreme Court of Appeal judge who retired at that point, who headed up the King Committee. It's been described as one of the most extensive documents on corporate governance. I think in our jurisdiction, undoubtedly, it is one of the most extensive documents on corporate governance. The beauty of King, though, and as I said, the entity itself is a microcosm in a much larger macrocosm. King underscores, or the King 3 report underscores, how important it is to pay heed to all stakeholders. Stakeholders in the King report include persons like the government, employees, socially, environmentally, as you said yourself at some point.
Mm.
So all of those issues are dealt with in King, the King 3. Of course, it does not ignore that the entity has a particular business purpose and objective. So King 3 really calls for what is an ethical and responsible approach to corporate governance, and it calls for a balancing between the individual stakeholders' interests. Strategically, one has to ensure the directors and the board of directors that they achieve the strategic goals of the company, but also paying heed to the stakeholders' interests. And as I indicated, it's broader than that.
Right. And perhaps we could just touch on the role of company secretary. This is an office that
Sure.
that has to be occupied, right? You have to have a company secretary.
Yeah, well, of course, with the limited companies and the listed
Yes.
companies. The secretary himself has a very strange role because, as the name suggests, he is a secretary. So he's obliged to ensure that the administrative functions of the board are done effectively and efficiently. But in the same breath, he's also obliged to ensure that the directors comply and the board complies with the legal requirements. The Companies Act also requires specifically of the secretary to ensure that the annual financials, which have to be filed annually with the CIPC, are filed, and the secretary himself must ensure that that's done. The secretary, as I've indicated, apart from that, ensures that the administrative functions are dealt with. King 3 places another additional obligation, which is the induction of directors and ensuring that directors are properly trained and the like. So he also has that obligation, he, she, whomever the secretary might be. I think, though, it's very important to understand that if one has these structures, firstly, if you're obliged to have these structures, by way of the Companies Act, listing on the stock exchange or otherwise, you must ensure that the office bearers are literate in their particular task and aspects. You obviously just can't have any Joe from the street coming in and being your internal auditor.
Now, I think that's very, very important because in terms of the BEE legislation, and there's a lot of fronting, so shareholders are given shares, they're asked to act as directors and managing directors without really appreciating this is a very, very important role, and it's illegal to be fronting,
Sure.
first of all. And then second of all, you could be visited with severe consequences
Sure.
if you don't understand the role that you have to play and the consequences thereof.
Well, you know, the unfortunate reality of fronting is that it usually takes advantage of the plight of the poor.
Right.
And it's usually the individual who is not literate in company structures and the like who's taken advantage of. You know, we dealt with fraudulent purpose and fraudulent carrying on of the company and the like. It's a prime example. You can't put someone in there for namesake or color's sake. And there's constitutional court decisions and the like, the all pay decision and the like, which says you must obviously ensure that these people have some managerial purpose as well.
Right.
You can't just put people in there for the purposes of attaining business. It's unconscionable, and I've seen some of these arrangements, so I apologize. Well, I apologize for a little bit of disdain, but on occasion you see a gardener who's now involved in a company, but he's got a loan owing to the company for his purchase of his shares, and he'll be paying that loan indefinitely, and his family will never see a cent of it. So those are those ruse transactions.
So you could be a shareholder, the company could be making a profit, but you couldn't see 1 cent of it simply because you have a loan that you have to pay for your shares. And the loan is extended by the company in which you own the shares.
That's exactly what happens. So it's really to bring up your BEE scorecard. It's astounding that people would think this creatively, and I think that's what King 3, that's why it's so important. Company rules are so important to ensure that you act ethically. Ethically, you know, it's fundamental to the responsibilities and the immunity provided in terms of that Companies Act and the structures of the company itself.
So this world-renowned King 3 report really sets out the basis of corporate governance, how you should play by the rules, what ethics are, and it really sets the boundaries which every active director or shareholder ought to know of in detail, Mom. Well,
you know, it doesn't set it out.
Yes.
The beauty of King 3 is that it spells it out.
Spells it out.
It's a document that you could actually just sit down and read by yourself. For the most, King 3, though, recognizes some degree of, to a large extent, common sense. So it's a proponent, it propounds the risk-based approach to running your business. There's so much of common sense in it. You know, talking properly and effectively communicating with shareholders if you're the board of directors, ensuring your risks are properly looked after and you've catered for your risks and you've considered the possibility of the risk happening, and you know, it's just really common sense. And when you read King 3, it spells it out completely. And the thing is, when I read it, I wondered why would the King Committee have to actually spell it out? Because you have to consider your risk if you're running a business. It's inherent in business. But it makes you wonder then, how do we run businesses? And are these just like pipe dreams that we chase and hope for the best and wait for the best? You just don't start on a pipe dream. You don't start on a dream.
Right. Now, it's interesting, Mohammed, that a lot of companies have this thing called corporate social initiative, and where they say they have to invest in some or other entity. For example, a tribe or a group or of let's say, disaffected people, or a charity. Now, what you're saying is very important, because it does presuppose one has to be literate in order to participate in the affairs of the company.
Sure.
I mean, in this case, there's no assurance that all of those people that we're including are literate.
Well, when I say literate, I of course don't require them to be literate in the sense of being able to read, because people can help with that. I mean literate in the corporate sense, of course.
Yes, yes.
The thing is, though, that it's very easy to dress up a report and hoodwink individuals. More often than not, I mean, I look at reports and I'm like, what the hell are they talking about? So if they're saying this fancy stuff in here, it has to be fine.
Right.
But one of the requirements of what they call integrated reporting in King 3, and the Companies Act also requires to a large extent integrated reporting, risk-based, financial reporting and the like, is to ensure that you communicate effectively the position of the company, the risks, the financial position and the like. And people should understand that's the fundamental requirement. So you, of course, have to tailor your reports as a director, as a board of directors, to your audience. It's easy to gussy up a pig.
Right. Well, unfortunately, we've come to the end of our time and the end of the show. All that is left for me to do is to thank my very special guest, Mohammed Desai, advocate of the High Court of Johannesburg, of the High Court and practicing at the Johannesburg Bar, who's been very, very helpful in trying to make us understand the question of corporate structures and corporate governance. We've tried to cover the shareholders' responsibilities, rights and obligations, that of the directors and that of other members of the board, the audit committee and the company secretary. Mohammed, thank you very much for joining us tonight. It's been really a pleasure. And to you, the viewers, we hope that you've benefited and ask that you join us next week at the same time, same place for another episode of Legal Ease, the show that converts legal jargon into legal ease. Assalamu alaikum wa rahmatullahi wa barakatuh.